Welcome to the Saturday HOA Brunch presented by Angius&Terry, LLP. Please sit back, relax, and join Brad Epstein, Jonathan Broderick, and Viana Barbu for an hour of entertaining information about HOAs and HOA law on AM 1380, The Answer.
I think it's Boxing Day. Did you know that?
No, I didn't know that.
Yeah, today's Boxing Day. I don't know what it means. The only thing I could assume is it means box up all of the gifts that you didn't like and take them back to the mall and wait in line and return them.
This is a Canadian holiday?
This is a Canadian holiday. Has nothing to do with putting the gloves on. But we're here to put the gloves on and continue the fight, right? To advocate for community associations and help listeners understand what they are.
That's right. So we're all about community association law. With us today is Jonathan Broderick. Good morning, Jonathan.
Yes, and I guess what is this happy day after Christmas? Frank Jolly's back in the sticks. You're joining us, Counselor Brad Epstein. If you want to call in and decided that you're going to tune into the Saturday HOA Brunch today, give us a call, 888-923-1380, 888-923-1380. 1380. A couple of things to take care of first. If you've been looking for our previous episodes on the websites with the holiday crunch, don't worry. Next week they'll all be they'll be loaded up on the website, so you'll be able to catch up on a couple of episodes if you've missed them the past couple of weeks. So, like you mentioned, we're the Saturday HOA Brunch. We talk exclusively about community associations. We've talked about 60-minute board meetings, insurance, some of the industry organizations, pet restrictions, elections, association security, new bills and lobbying on behalf of communities. And so what do you want to talk about today?
Well, today is going to be a little bit different. The year is getting on, right? The year's
old. Almost over.
Right, exactly. So we're going to talk today about grandfathering. This is a legal term of art, grandfathering. Grandfathering means an exception to a CC&R restriction or to a rule that allows all those already doing something to continue doing it, even if they would be prohibited by the new restriction or rule.
Okay, time out. So first, let's get to this. So this is something we get excited about, right? Because then we know somebody's actually tuning the dial to 1380 on a Saturday morning. But one of our loyal listeners actually emailed us, right?
That's right.
And had a question, and they were playing Battle of the Board Members at home. A contestant. Oh, they were a contestant. Okay. And they wanted to know why one of the questions was true.
Exactly. So today's show is inspired by that email question from one of our loyal listeners. They wanted to know why the following Battle of the Board Member question was true. And we didn't have enough time, Jonathan. You were actually out at that charity event, so you were not in studio when we were talking about this, and we ran out of time. And so what's the question? The question is, if a rule has not been enforced, a board may have no choice than to grandfather in old violations. True, false? And so this one is true.
For a few reasons, right?
For a few reasons. So again, if a rule has not been enforced, a board may have no choice than to grandfather in old violations. So what are we talking about here? If a board of directors, if they're not enforcing a particular rule, and that happens because you have boards that come on through the years that have different values, different ideas about how the association should be run. And so there's slight variations. Maybe you could say that one board's a little bit more tougher, but they're going to be
the Iron Fist board.
Right. Whereas the next board might be, the Iron Fist and the Velvet Glove. If a rule has not been enforced, a board may have no choice in a grandfather in old violations. And so it could be certain types of rules, such as enforcing what the front yards are supposed to look at, junk in the front yards.
Or parking your vehicle in certain locations could be prohibited. And you might have one board that says, well, we don't care where you park. We're not worried about that. We're more worried about landscaping. And then you have this board that comes in and they say, oh, no, we're going to enforce everything to the T.
Different platforms. Or how about one that's kind of common is where you have a no-shed policy, SHED. You can't install a shed.
My mom would like to enforce that on our family dog, but it's not going to happen.
Hysterical. And so, for instance, there's a restriction, a rule that says no sheds may be installed above the fence line. Okay, that's kind of common.
Yeah, no, I think actually if one of their neighbors had that enforced against him. He built this nice, great shed, and it was above the fence line.
Right,
Boom,
right.
got a letter.
Got a letter
from the association. Said, hey, take that shed down.
That's right. And so let's say that you had a rule, and we're not talking about a CC&R restriction, so that's why this one's a little bit different. You have to sort of separate out enforcing rules versus enforcing CC&Rs, and we'll get into that, dig into that. And so if you have something that's like a permanent installation, a board of directors doesn't enforce against owners who have installed sheds, but now they want to, so it may be, we're not going to have you, owner, go ahead and remove your shed. But in the future, you can't install sheds if you haven't done so already. That's sort of the grandfathering in. And so it's true for a couple reasons. First, you have a statute of limitations also of 5 years. It's a deadline for associations to take action through a lawsuit. And otherwise, you miss that deadline, and what do you think the judge is going to do?
Throw it out.
He's going to throw it out. That's right. So the biggest example is you get hit by a bus that breaks your leg, and you wait more than 2 years. You hobble into court, and the trial judge says, no, you waited more than 2 years. We can't help you. So that's the statute of limitations. You wait, and there's a 5-year statute of limitations for CC&R violations. That's a long time, don't you think?
5 years.
5 year.
Yes.
5-year deadline for boards of directors to file a lawsuit in enforcement of a CC&R violation. Pretty long statute of limitations when comparing it to personal injury, which is just 2 years. Just 2 years.
Interesting.
And so the second reason why this is probably true, that if a rule has not been enforced, in contrast to a CC&R provision, rules are a little bit more difficult to enforce, arguably, because CC&Rs, Jonathan, what do you think the difference is between where you find your rules versus where you're going to find a CC&R restriction? It's this. Go ahead and take a guess. You look like you have the answer.
Well, I'm sorry. Kentucky made a big shot against Louisville, so I was distracted. So what's the question again? Ask me the question one more time.
Right. So you're become a new board member, and you say, where can I find our governing documents?
Don't call a realtor, right? No, that's a joke. We love realtors.
And so a rule is not going to be recorded in the county, filed with the county recorder, whereas a CC&R provision is filed in the county recorder. So over time, from our law coming from England, we have been sort of designing this idea that documents that are filed with the county recorder, they give what's called, quote-unquote, constructive notice to the world and to owners at associations that this rule, which is a little different, elevated a little bit higher, it's a CC&R provision that's filed with the county recorder. So a little bit difference because in our question, it was a rule. It wasn't a CC&R provision.
I think you just answered the question for me.
I think so.
Great.
And a third reason why this following question, if rule has not been enforced, board may have no choice than to grandfather in old violations. Why that is true is that a court's going to probably say that the association may not enforce that rule against those who have already put in sheds, right? Is due to the legal principles, as I know you already know this, estoppel and waiver.
Yeah.
Estoppel and waiver, right?
One of my favorite things to talk about, estoppels and waivers. Hey, so we've just started, and we are winding down 2015. So when we come back from the break, we are going to analyze the concept of grandfathering, and we're going to review a court case. And the court case is Villa de Las Palmas Homeowners Association versus Terrifage. So when we come back from the break, we look forward to analyzing grandfathering. We'll see you in a bit.
If your community association has a good relationship with their current management company, you can stop listening. However, if you are struggling with your current service provider, we'd love to talk with you to see if Omni Community Management would be a good fit. Transparency, education, communication, and trust are just 4 of the qualities that set Omni apart. This is Rolf Crocker, CEO of Omni. Call us at 916-965-8964. That's 916-965-8964. Online at omni-mgt.com. That's omni-mgt.com. Omni Community Management, your friend in the community association management industry for over 20 years.
Have you ever heard of the saying a person's home is their castle? Of course you have. But sometimes a construction defect can turn your castle into a catastrophe. If this happens to you, you need proper and professional representation. You need Angius&Terry, LLP. For over 30 years, the attorneys at Angius&Terry have been effectively serving homeowners and community associations, recovering more than $500 million on behalf of their clients. Angius&Terry strives to ensure that your construction defect claims are prosecuted in an aggressive and cost-effective manner. Angius&Terry will also continue to work with homeowners and community associations after the construction defect claims are concluded to make sure that the money received from builders is spent wisely and that your interests are protected during the repair process. Don't let a construction defect turn your castle into a catastrophe. Call Angius&Terry LLP today at 916-567-1400. That's 916-567-1400. Online at angius-terry.com. Angius&Terry LLP. Professional Parking Enforcement, or PPE, was created to provide effective parking solutions for all types of parking issues. PPE focuses on parking problems of HOAs and can quickly eliminate these problems through their system of property inspection, violation updating, ticketing, and enforcement. Contact PPE today at 702-283-0628, online at ppenv.com. PPE, promoting harmony in HOAs through parking and compliance enforcement. We take time to understand your community's needs.
Silver Creek Association Management.
We solve small problems before they become big ones.
Silver Creek Association Management.
We help make your community a better place to live.
Silver Creek Association Management.
It's what we do, because an association is more than just a bunch of homes. It's a community of people. We work with you to make better communities so homeowners can enjoy better lives.
Silver Creek Association Management. Online at sc-manage.com. That's sc-manage.com.
This is AM 1380, The Answer.
You're listening to the Saturday HOA Brunch, presented by Angius&Terry, LLP. And now your hosts, Brad Epstein, Jonathan Broderick, and Viana Barbu on AM 1380, The Answer.
Well, welcome back to the Saturday HOA Brunch. It's a crisp December morning in Sacramento, and we are talking about grandfathering today. And on a side note, if the listener that sent us that email would like to call in and has a couple of tidbits that they'd like to add or has a few more questions, feel free. 888-923-1380, 888-923-1380. And so we're going to analyze a case, right, with grandfathering.
Sure. Before we get to that, Jonathan, we're going to talk about the legal principles of estoppel and waiver. So that was the third aspect. So if you...
Do you want me to cover that, or were you going to handle
that?
No,
please, go ahead. So estoppel and waiver, these are legal principles. Estoppel is looking at actions in a backwards fashion, looking at what you had done that affects folks, whereas waiver is actions that will affect what you do in the future. Estoppel, that's when you have taken action, such as with the sheds. Use our shed example, right? So the rules say, well, you can't install a shed above the fence line. That's our example. And in this case, the board of directors, for years, they failed to enforce that provision.
They didn't enforce it, but they had up to 5 years, is my understanding.
For the statute of limitations, right?
Right. So at
which
year
is a legal
4
defense.
and 300 days, they could enforce that rule.
Arguably, they would not be barred, but as a defense in a court of law. But in addition, we have equitable defenses, estoppel and waiver. So estoppel is, okay, well, the owner comes to you and says, I'm going to go into court and I'm going to defend against this lawsuit that you filed within 4 years and 351 days. And then the owner says, you might try and enforce that against me, but I had relied to your detriment on your failure to enforce by installing the shed. So I changed my position because I didn't think that you were going to go ahead and enforce it, because you didn't enforce against my neighbor here or my neighbor there. So looking backwards, estoppel, you're stopped. And waiver, that's this action whereby an owner comes to you and says, well, I'm going to go ahead and install a shed because you have not installed this, and so you've waived your rights, association, to go ahead and enforce this against me. So these are different reasons why, in fact, it may be true that if you have not enforced a rule in the past, they may have to grandfather in violations. But in the future now, you can say, no, we're changing things. We're now going to enforce it. We have a rule. We're going to adopt this rule, re-adopt this rule, change it a little bit, and say from now on, this is how it's going to be, but we'll grandfather in those folks who had paid money to install sheds. You're nodding your head like that makes sense. Fantastic.
It does, absolutely.
Fantastic.
Clear as mud.
So then we will contrast this situation of a rule with a CC&R restriction. And this is the case of Villa de las Palmas Homeowners Association v. Terrifage, Terifag. And if you want to look that case up, nowadays it's so easy to look up cases. It used to be where you have to go to the books.
Internet. Now you just go on the internet, right?
Right. And all you would have to do is put in the word Terrifage, and up this case would come.
It would just pop up.
It would just pop up. Whereas when I was first taking steps to be a lawyer in law school, and even after I became a lawyer.
You go out, and then there's like all these stone walls, and you go up to it. And
Exactly. these tablets, Terifag.
Yeah, Frank Jolly, our production engineer, one more time.
I think he's checking out this case.
He's always interested in cases.
Right, so it's found in the books, in the archives at 33 Cal 4th 73. So that volume, Cal 4th, that's the Supreme Court cases.
Is this an appellate court?
Book 33, page 73, back in 2004. This case started out, though, this is another one of those miserable disputes that just take forever to resolve. So it started, Jonathan, in 1999.
1999.
Right.
I was still in high school in 1999.
Right, before the century turned. So down in Palm Springs, you have the association, and it's about 24 homes in an L-shaped. The court thought that was important for whatever reason. They even pointed out that between the homes, so it's like a condominium type situation, that they had pony walls, and the court described the pony walls. I don't understand why they describe pony walls at the association about a case that has to do with a doctor, a veterinarian who bought a unit in the development, and she had a dog named Lucy, a bulldog. And although the association had a rule against pets, no pets at all. So it was a no pets rule.
No pets.
No pets.
And that should be disclosed before you buy, right?
Well,
into a community
good.
Like this.
Right. And so
they should go, hey, I want to sell you this unit, and I know that you're going to love this community, but if you love animals, you cannot have pets in this community. Right?
Right. So no pets policy. And so the doctor, she did know of the rule, but was not given the rule. That's what she testified to. She said, I knew of the rule, and what happened was she had her dog Lucy, but Lucy passed away, as all dogs do.
Yeah, they all go to heaven.
Right, so it's a vacation condominium in Palm Springs, Dr. Terifage, a veterinarian. Then she got a new dog. She got a new dog.
What'd she get, a Rottweiler, or do we know what kind of dog she got? St. Bernard? Basset Hound?
When the bulldog Lucy died, Dr. Terifage got another bulldog.
Another bulldog. All right.
Bulldog. So this is a vacation condominium, and Dr. Terifage would like to come in with her new dog, and the California Supreme Court told us the name of the deceased dog, Lucy. Maybe they liked that name, but they didn't tell us what the name of
Everyone
the new
loves
dog
Lucy.
was.
Yeah.
I don't know why they didn't tell us the name of the new dog.
They probably wanted to just, not have that information public. The name of the dog. The new dog.
Right. Protect the innocent.
The dog's interest and all that stuff.
I got you. And so the association at this point said, well, we're going to enforce this rule. We're going to enforce our no pets rule. So remember, this is a rule, not a CC&R restriction. So a little bit different analysis, arguably. And so the doctor brought her dog, and the association said no dog, and they fined her. They started
how
imposing
much?
fines
Do we know how
against
much
her.
they've levied fines?
No.
Okay.
I don't know anyway. If anyone knows,
call in.
Sure.
We got a gift card. If you can tell us how much they fined the veterinarian in the Palm Springs condominium case, we'll have a gift card for you.
Right. Some of our attorney friends, they will
have
actually
friends?
look behind the case and make some calls or figure out what's going on as far as the little hidden details. So we know some people have done that, but not in this case in particular. I don't know. This case has been around since 2004. That's when the California Supreme Court published it. So it's been around a while, about 11 years. And what we do is we can rely on precedent in this case because it's a California Supreme Court case. This is the law of the land, unless there's a statute that's made later by the legislators that say we're going to overturn what the court says. So that's how it's done. You have state laws by the legislators, and then you have the Supreme Court or the Court of Appeals or regular court, and they try and interpret the laws.
Yeah,
right?
That's the burrito supreme right there. Cheese, sour cream, and guacamole all in
the
one.
Supremes. And so what happened is the association went in and they sued because the fines wouldn't work. And so they sued the owner. And when they sued the owner, this is sort of the little twist. So I want to, before we have our caller come in, I just want to finish this up. So the association asked for a preliminary injuction. Jonathan, do you know what a preliminary injunction is? It's a request for a preliminary injunction.
It's probably,
it's a request for...
It's probably for them to step in and take another look.
Almost. So this is a lawsuit by an association against our veterinarian about trying to enforce the no pets rule. Okay, you want to go to our caller?
Yeah, let's go to our caller. I'm going to Google preliminary injunction so that I can give a better definition. So we have Carol on the line. Good morning, Carol.
Good morning.
How are you?
I'm doing well, thank you.
Well, we appreciate you listening and calling in. We hope you're enjoying our day after Christmas / Boxing Day celebration of the Saturday HOA Brunch.
Yes, and thank you for getting to my question I sent in to Brad.
Oh, we try. We're busy, but we definitely appreciate our listeners, and we enjoy receiving those questions so that we can add a little more content to the show. So you have a question for Brad. Go ahead, and let's hear it.
So I've been listening, and I think I kind of hear the distinction now between CC&Rs and rules. And what came to mind when he made that statement about not being able to enforce a rule if you've been letting it go is I was thinking more of, which is in our CC&Rs, we have a rule about dogs being on leash in the common area. And we do have a resident who for years has let their dog off leash, and it hasn't been enforced by previous boards. And we've just redone our CC&Rs, and so I'm wondering now, are we going to have a problem should the owner challenge that?
I have a question just real quick, Carol. What kind of dog is it? I'm just curious, because we were talking about Lucy, and she's a bulldog, and everybody loves dogs. What kind of dog is it?
It's one of those little herding dogs, those little black and white.
Oh, yeah, those are little smart dogs, yeah.
Yeah.
Like a little sheepdog.
Run real fast in circles.
Okay, so I think that the association will indeed be able to enforce a CC&R restriction against allowing dogs in the common area. I don't think that the owner is going to be able to say, oh, because you didn't enforce this in the past, you are not going to be able to enforce it against me in the future. And in particular, Carol's example is almost exactly parallel, almost consistent with this case that we're going to talk about. And Carol, in this case, the difference is that the association at this point, they asked for his preliminary injunction, the court turned them down, and the association, you know what they did? They went out and they amended the CC&Rs and put in a no pets CC&R provision. So similar to what Carol's talking about, right? The board of directors, Carol, right? They didn't enforce that policy too strictly, but now you have a CC&R provision that says no dogs that are out of control. They have to be leashed or under control, or leased and under control, right, Carol?
Right.
Yeah. So I think any court in the land with a reasonable court would say, nope, the association, you can enforce it. Nope, that's not a good defense by the owner to say that they're grandfathered in or anything like that.
Great.
Excellent.
Thank you so much.
All right, Carol, thanks for calling. Did you want to give a shout-out to anybody during the holiday season?
Just the folks in Woodland in our HOA.
All right, Woodland.
Awesome. Thanks for calling in, Carol.
Thanks, Carol.
Have a safe New Year's celebration.
Yeah.
Thank you.
Bye.
All right, we will be back with more. What are we going to talk about? More about this case, grandfathering?
Yeah, we're going to get into Dr. Terrifage's case.
Awesome. We'll be back. Stay with us.
Having trouble understanding your community association's reserve study? Does your HOA's reserve study seem to be written in a strange language? Hi, I'm Robert Browning, owner of the Browning Reserve Group. At the Browning Reserve Group, we have been providing easy-to-understand reserve studies since 1999. We actually listen to our communities and help them plan for the future. Find us online at browningrg.com. That's browningrg.com, or toll free at 877-708-0600. That's 877-708-0600. Clarity from complexity. The Browning Reserve Group.
If you are a community association or manager, you know your banking relationship is vital to your success. At Sacramento Bank of Commerce, a division of Redding Bank of Commerce, our industry expertise and personal attention make that task a breeze. With our specialized banking, lockbox, online banking, and remote deposit capture, trips to the bank are no longer necessary. And Sacramento Bank of Commerce can help your communities with a loan to repair, replace, or upgrade the investment. For local decisions and in-house processing, get in touch with our team today. Call Sacramento Bank of Commerce at 916-772-0131. Member FDIC, Equal Housing Lender.
Did you see the story about the Homeowners Association? I wonder what their residents think.
I don't know, but I love my condominium association. The place looks great and is well managed, and our property values are increasing.
Well, that's a good thing.
Community Associations Institute, CAI, has helped us build a great community. They have tools for safeguarding our investment, including education for our board and professional training for our manager. Just visit CAI at responsiblecommunities.com.
Okay, responsiblecommunities.com.
News, opinion, insight. AM 1380. The Answer.
You're listening to the Saturday HOA Brunch presented by Angius&Terry, LLP. And now your hosts, Brad Epstein, Jonathan Broderick, and Viana Barbu on AM 1380, The Answer.
Wow, are things heating up in the studio? Production engineer Frank Jolly comes in and says,
we're talking about the facts of this case.
Hey, I just Googled this, and I can tell you how much the fines were that were levied in this case, right?
Well, how much?
What did he say? $15,000.
I don't know. I think the facts that Frank has are a little bit skewed. And so we're having a heated discussion in here about this court case. In that Frank, he says that, this was a
order
mobile park, right? Mobile home park.
Mobile home park.
That is just not. I'm looking at the official court case from the records of the California state. Yeah, absolutely. Here. He's looking at the newspaper. So here's the first line of facts.
He got his on TMZ. No, he was looking at TMZ.
It says, Villa de las Palmas is a relatively small condominium development consisting of 24 units located in a single L-shaped building. So a little bit different than the facts that Frank's looking at.
Yeah, Frank's was mobile home park with armed barricades and grenade launchers. No.
And secondly, so Frank is saying, the owner was fined $15,000, whereas this court case says that the court awarded the association $15,000 in attorney's fees.
Attorney's fees.
Yeah. So a slight difference in facts according to between the court case, official court case,
between the official Supreme
TMZ.
Court case.
That's liberal journalism, though.
There you go.
All right.
So this is the neat part in the case. So this association is filing a lawsuit based on their rule. They go to the court, and remember, Jonathan, so you looked up preliminary injunction. You could tell everyone what preliminary injunction is.
Shut up, your mouth is
No.
A preliminary injunction that's when a court awards temporary relief to the requesting party in a case. So typically, like in this case, the association went to the court and they said, we're going to sue for enforcement of this rule. And they said, and pending the resolution of the case, Judge, we want an order that this terrible bulldog cannot come to
Lucy.
No,
Lucy, the new bulldog. Jeez, I'm sorry.
Cannot come
Poor
to
Lucy.
the
Rest
association.
in peace, Lucy.
Right, this little dog can't come to the association pending resolution of the case. And the court said, no, I'm not going to grant you this preliminary injunction because I don't think you're going to win the case. Wow. So this is right. This
The
is
reasonable court.
This is right at the beginning of the case. And so what do you think the association does? Do you remember what I told Carol on the phone earlier?
The association goes out, they get together, they probably send it out for a vote and say, we're going to rewrite the CC&Rs.
They said we're going to amend the CC&Rs.
Amend them, yeah.
We're going to amend them, right. And actually, Dr. Terrafage, our veterinarian, had gone to the association a couple meetings and said, hey, everybody, let's get rid of this no pets rule. And it wasn't voted. It wasn't voted on. No one said it died for lack of second, as they died for lack of second. And so the association went out and they amended their CC&Rs. They have a no pets CC&R provision now. Different. According to this court. No pets.
And there's probably
CC&R.
a definition of what a pet is. Because people probably try to bend the rules and say, oh, that's not a pet, right?
Any reasonable argument by an owner. We've heard. Okay, so
I don't want to jump off track here. Now, I'm assuming, though, an owner could have a companion pet ordered,
No,
right?
you're not jumping off track. That's a great question.
So I move into this association, and I know that you can't have pets. But my doctor and psychologist told me that I need to have a miniature pony for a companion pet because it makes me feel better. Now, is what law is going to win, right? Is it going to be state law, or is the association going to be able to say, no pets whatsoever?
Even though you as a disabled person comes to the association and asks for a reasonable accommodation to the rules so that you have a level playing field when it comes to your residing at the association. The law, both federal and state, as you know, you threw me a softball question on that one. So
Bam, hit it out of the park.
Right, so that law, the fair housing laws,
and you don't want to, the FHA, right? Or no, sorry, what is I'm stumbling here. It's the...
you almost had it.
You don't want to get in the mix with this...
DFEH.
Yeah, the Department
of Fair Employment and Housing.
You don't want to mess with those guys, right?
They're pretty tough.
They're
pretty
tough guys.
Right, tough and fair. And also you have the California Department of Housing and Urban Development. So you have both the state government and the federal government, and they both provide that folks can have residents, tenants, owners at associations can have a companion pet.
Got it.
So back to our case. The association went ahead and they amended their complaint. What does that mean, amended their complaint? They filed a lawsuit. In every lawsuit, the document they file,
changed it.
Right.
They revised
that's called the
it.
complaint, just terminology.
Yeah.
Right. So the complaint is what the plaintiff files. The answer is what the defendant filed. So the defendant, in this case, is the owner. The plaintiff is the association. The association amended its complaint, and it goes to the trial court. At the trial court level, the court rules in favor of the association. Winners.
All right.
Right. The owner made many different arguments, which we're going to go through their different arguments. In particular, they're saying, well, we should be grandfathered in. We should be grandfathered. You should allow me.
There's that term.
Right. You should allow me as a pet owner grandfathered in at the lease. So that the owner really tried different ways to try and win the case, all different types of arguments. Now think procedurally where this case went. So it was an association fining the owner, right? So they took him to a hearing. Then they filed a lawsuit. The association filed a lawsuit.
Yeah, and those as we know, those can get expensive, right? Filing a lawsuit.
And courts do a lot of different things to try and help the parties settle, trying to compel them to settle. One of the main tasks that judges do is to keep cases out of their courtroom.
Right,
really.
and so then they'll use like a mediator.
And close. In this case, the court said, I'm ordering you, I don't know how I was able to do this.
To call Ace Ventura Pet Detective.
Probably a court rule, probably a local court rule, and he ordered the parties to arbitrate. Non-binding arbitration is what the court ordered the parties to do.
Okay, and there's an acronym for that.
Almost. Right.
Jeez, I'm just coming up short today. It's just like my golf game.
I'm gonna give it to you. So you're saying ADR, alternative dispute resolution, is what the court ordered the parties to comply with?
Participate in.
Okay, so arbitrate. So what's the difference between mediation and arbitration? You got that one nailed, right?
This is like beating a dead horse. Let's not bore the listeners.
Arbitration is where there's actually an appointed judge for the parties who makes a determination, a ruling on exactly who's going to win or lose. In contrast, you have mediation, where you have a third-party neutral who tries to compel, cajole, convince the parties to come to a resolution. And so in this case, they didn't tell us what happened in the arbitration, but we do know what happened. The association won this case. The association won this case at the trial level.
And they were awarded, right?
$15,000.
$15,000.
The association asked for $18,750.
Oh, so they came up close, right?
They came up close, and the court looked at the billings, is what happens in this. At the end of the case, the winning party will submit their costs. They'll make their motion for costs, which are like your filing fees with the court and any kind of service costs where you personally serve the party.
Or if maybe and maybe not in this case, but if they had to hire a professional expert or something, those fees are all going to be included.
Sometimes. That's a great question.
Sometimes, not necessarily in the dog case, but there's other situations where maybe I could imagine if you were like reconstructing an accident or something that happened, right?
Sometimes.
And you had to bring in somebody that was forensic oriented, things of that nature.
Good point.
Or a doctor if there's an injury.
Right. At trial, right. So it's not every cost that you incur as a plaintiff when you are victorious that the court's going to award you. They're not going to give you every fax cost, every mailing cost.
You can't say like, hey,
cost.
when we came in to arbitrate in the clubhouse, we decided that we were going to go to Noah's Bagels and we had breakfast, so we want to include the cost of feeding the parties for this.
Right. The meeting that you had with the client before you went into trial where you had bagels, right, that wouldn't be covered. But most likely any kind of diagrams that you use at trial, and most of the time the expert opinion at trial, the depositions are another story. So that's typically you're a lot of times you're not going to get those costs. But the big costs are minuscule compared to the attorney's fees.
Oh, yeah. Those can get pricey, right?
Right. So in this case, the plaintiff asked for $18,750 when they won the case, and the court said, "I'm going to chop it down to $15,000. I think some of these costs you don't deserve."
They didn't have to accept it, did they? The $15,000. They could have said, "No, we're going to keep our foot on the gas, and we're going to try to get our $18,000." They could do that, right?
And are you saying through
and the
an
judge
appeal?
Would probably, they could appeal it.
Okay.
But the judge would probably say, "This is ridiculous," right? You're not gonna make the court happy if you don't accept the resolution that they're offering.
Well, it would be an appeal to the next court up, right? What happened is our owner did appeal the case.
Oh, well, they did.
To the Court of Appeals.
And they said, nah.
And the Court of Appeals affirmed the trial court's decision in favor of the association. So what did the owner do? The owner appealed that decision to the California Supreme Court. And the California Supreme Court affirmed the Court of Appeals.
Okay,
ruling
so there's
in favor
a lot
of
of
the
affirming
association.
going on. Got it.
Exactly. So now we want to know how the court had ruled based on our idea of grandfathering in. So the association, they were able to defeat the argument by the owner that the owner should be grandfathered in.
Cool. Hey, did you hear that background music? That means we've got one more segment left, a brief segment. So we're going to try to wrap things up with our grandfathering episode, our Boxing Day edition of the Saturday HOA Brunch. And you know what's exciting is I've got to do some counting, but I don't know if it's next week or the following week, but we're coming up on our 50th anniversary episode. 50 live weeks in a row for the Saturday HOA Brunch. That's kind of exciting to me. You're not looking...
Well, I don't think it qualifies as a 50th anniversary.
Oh, okay. 50th edition, 50th episode. All right. Well,
how about 1 year anniversary?
Yeah, that's okay. That works. So when we come back from the break, we're going to wrap up the Saturday HOA brunch, and we'll be back shortly.
Hi, I'm Morgan Fussell. My company, Broadband Agreements, negotiates cable television and broadband right of entry, access, and compensation agreements for your communities. At Broadband Agreements, we offer a free review of all agreements with a signed letter of authorization. Broadband Agreements will improve your community's income and/or savings, or you don't pay us a dime. Visit us at broadbandagreements.com. That's broadbandagreements.com. Or call me, Morgan Fussell, directly at 916-939-5026. That's 916-939-5026. Broadband Agreements online at broadbandagreements.com or 916-939-5026.
Thanks a lot, Morgan.
The challenges presented by today's economy and rebounding housing market is forcing many homeowners association boards of directors to operate their HOAs more like a business. It's a balancing act of trying to stay solvent and still provide homeowners with quality amenities and services. One of the main challenges HOA boards are facing is attempting to recover unpaid HOA fees owed by delinquent homeowners. Collection efforts are often very time-consuming. If you want to get the HOA fees collection monkey off of your back, call ATC Assessment Collection Group. ATC is an attorney-supervised collection company providing collection and foreclosure services to HOAs in both California and Nevada's most recognizable communities. Get back to what you actually volunteered to do as an HOA board member. Effectively oversee your community. Call ATC today at 916-641-1410. That's 916-641-1410. Online at atcacg.com. That's atcacg.com. ATC Assessment Collection Group. Professional Parking Enforcement, or PPE, was created to provide effective parking solutions for all types of parking issues. PPE focuses on parking problems of HOAs and can quickly eliminate these problems through their system of property inspection, violation updating, ticketing, and enforcement. Contact PPE today at 702-283-0628, online at ppenv.com. PPE, promoting harmony in HOAs through parking and compliance enforcement. We take time to understand your community's needs.
Silver Creek Association Management.
We solve small problems before they become big ones.
Silver Creek Association Management.
We help make your community a better place to live.
Silver Creek Association Management.
It's what we do, because an association is more than just a bunch of homes. It's a community of people. We work with you to make better communities so homeowners can enjoy better lives.
Silver Creek Association Management. Online at sc-manage.com. That's sc-manage.com.
AM 1380. The Answer.
You're listening to the Saturday HOA Brunch presented by Angius&Terry, LLP. And now your hosts, Brad Epstein, Jonathan Broderick, and Viana Barbu on AM 1380, The Answer.
All right. That's the sign that we're back for this basketball game going on in the background. We've got to turn this TV off. Okay, so we talked about grandfathering and a big California Court Supreme case and Lucy the Bulldog. So I've got a question. We've got a couple of minutes left to wrap up the Boxing Day edition of the HOA Brunch. So how about an example where a court would probably rule that owners must be grandfathered in, where associations has previously allowed owners to install sheds above the fence line and then adopts a CC&R restriction prohibiting sheds. I think this is kind of, we're just jumping back. I want to make sure that this is clear as day. All right? So what would a court rule that an association, are they requiring that the owner remove their shed?
Yeah, so that's the situation that we have here.
Sheds.
And what we're talking with Carol earlier, and that is we're going to go ahead and we're going to adopt a CC&R restriction. And when you adopt a CC&R restriction, then you have all the owners vote for it.
Yeah.
And I think that no matter how you slice it, I think that bottom line is that a court's going to say, well, if all the owners voted for this change through the recorded document, through a vote, the owners, it's going to have some more weight when it comes to enforcement in contrast to a rule.
Okay, large community, and not a lot of owners live on site, and the board of directors is working diligently to amend a rule or CC&Rs, how many times do they have to send it out for a vote? And is there a chance that if they can't get enough participation from the members, that a court would just say, okay, there's a X amount of time where the court will make a decision on behalf of the board of directors to allow the amendment?
So what you have is you have a state law that does allow associations to go to court and get the court to deem the CC&Rs amended if an association goes out to the owners and they get at least a majority vote. So this is when a supermajority, Jonathan, is required pursuant to the CC&Rs
because
to
each
get them
set
amended.
of governing documents might have a certain percentage of ownership vote required to make an amendment.
Right, and it's going to be at least 51%, but there's some associations that go 75%. There's a requirement of 66% or 75% or 90% required in order for the CC&Rs to be amended. In that case, if the association gets 51%, they could petition the court. You go to your attorney, so we do this all the time. We'll petition the court when an association shows due diligence and a reasonable amendment.
Yeah, so the funny thing is you have these large-scale communities, and then an amendment for CC&Rs comes out, and a new rule is going to be enforced. And they had to have 70% of the membership approve this. And you have these bad apples that come out, and they go, oh, man, these tyrants, the board of directors, how did this happen? Well, guess what? 70% of the membership voted to approve this new rule, right? So maybe you need to point your finger at your neighbor and not at the board of directors, because they're just trying to, enhance and protect.
That's a perfect segue to the court's reasoning in the Terrafage case. So what the court said is no, you're not grandfathered in, and we're going to look at, we're going to look at a law, and we're going to look at a court case. And the court said, first, the law is the Civil Code Section 5975 in your Davis-Sterling Act. And this is the foundational basis for enforcement by association of the CC&Rs. It provides that CC&Rs are enforceable unless unreasonable. And so what this means is that there's the burden on the owner when he goes into court to say this rule is unenforceable because it's unreasonable. This provision of CC&Rs and no pets. And I like your little example because the court...
Oh, my companion pet.
Well,
my miniature
not
pony.
That one, but the one where you said, hey, owner, it may have a bad effect on you, but overall, all the owners, in your little example, 70% voted, we want to have the CC&R restriction. We want to have this no pets policy, and it doesn't matter if it affects an individual owner adversely or disproportionately. It's the benefit on all the owners, and that's what the law provides. And then
okay.
And then the court case they looked at is the Narstead case.
Oh, the Narstead case.
The cat case, and they said, just like we just said, if it affects you more adversely, individual owner, it doesn't matter because all the owners voted it in. The 70% voted it in, and they decided as a whole that this is what the association wants.
Wow. What a great day after Christmas / Boxing Day episode of the Saturday HOA Brunch. We've got a lot of exciting things coming in the new year, correct?
Correct. And let me just
we have
add
6 more days to think about.
We'll talk about next time so they can all hang on the edge of their seats.
Oh.
Why didn't this law that allows, that provides that all pets, that all associations must have pets, why didn't that apply? So we'll talk about that next time.
Perfect. All right, thanks for listening, and we will be with you next week. Have a great weekend.